Hey, welcome back to the channel where we help you break down real estate concepts to become a smarter buyer, seller, or investor. Today we're looking at the essential but often overlooked topic of the real estate legal description. You may ask yourself, well, isn't the property address the legal description of a piece of property? The legal description is a precise way to identify a piece of property. In fact, the statute of frauds says that all real estate contracts must be in writing and the piece of real estate must be adequately described. While the address may seem like enough, it is not legally sufficient for a deed. A legal description ensures clarity and prevents disputes over property and boundaries. For example, back in 1990, here in Tampa, a 20-mile section of a state road was changed from Buffalo Avenue to Martin Luther King Avenue. So if the only description you had for a property that you owned was something Buffalo Avenue, that address no longer existed. So you could see how a dispute could come about. Without an accurate legal description, contracts can become unenforceable, and title issues can arise that can span generations. Without the correct legal description, the title to properties cannot be validly transferred. Now let's break down the three methods that are used to describe real estate. The first method is metes and bounds. The metes and bounds method uses boundary lines to describe a property. Metes refers to distances, while bounds refer to directions. So this method is like giving specific directions that outline the border of a property. For example, I'll read a legal description to you using metes and bounds. Beginning at a point on the south side of Gary Street, 200 feet east from the corner of Hale Street, then proceeding south 100 feet, east 50 feet north, etc., etc., etc. When George Washington inherited Mount Vernon from his half-brother Lawrence, the property was probably described through metes and bounds. However, even though this is an old format, you'll still find properties today that are described using this method. Now remember, this system has to have a clear starting point in order to be efficient. Unfortunately, many times metes and bounds will use a natural reference that could move. For instance, if they say 50 foot from such and such river, rivers can dry up or rivers can flood. The flow of a river can change over years. Therefore, you could lose 10, 15, 20 feet of your property or gain depending on which way that river moves. So if you're purchasing a property that's described using the metes and bounds method, just make sure that there's a clear starting point. Obviously, we should always be getting surveys done on any property we buy. If you're purchasing a property with a loan, the bank is going to make you get a survey. But even if you're paying cash, you should always get a survey. They're the ones that should be figuring these things out, not us. Method number 2 is the plot map. The plot map is the most common method used, especially when it comes to subdivisions. All of the legal descriptions using a plot map are going to refer to a map that's been recorded with the county records. This map is going to show the lot size, street names, block and lot numbers, easements, and restrictions. An example of what a property description would sound like using this method would be Lot 27 of Candlelight Estates as per plot recorded in Book of Maps, page 30 in the office of the county, etc. Now, method number 3 is the government survey method. This method was introduced in 1785 in the far west US. It was supposed to standardize the way we describe property, and it uses rectangular sections in order to do so. This method will use principal meridians, which are north and south lines, baselines, which are east and west lines, townships and ranges, which are 6-mile square grids, and then sections, which is 1-mile squares within the township. An example of the way a property would be described using this method would be the southeast quarter of section 12, township 3 north, range 2 east of the Salt Lake Meridian, etc., etc. Now this method creates a lot of uniformity and it makes it easy to determine where a property is at in its particular size, but you have to understand the different lines. Again, another reason to always have a property surveyed before purchasing it. So while this is a component of the real estate contract that a lot of us don't even worry about as buyers and sellers and investors, it is an important aspect that we need to pay attention to. In fact, there was a case, 303 LLC versus Bourne. The court ruled that if a legal description is inefficient to create a contract, then it's also not sufficient for a deed. This means this can not only make a contract void, but the entire ownership of a property. So this is something that we need to make sure is looked at When you get to the title company, or if you have an attorney closing your transaction, you just want to make sure that the legal description is correct. Again, if it's meets and bounds, I might even ask a couple of additional questions. The main point I'm trying to get across is a legal description is much more than just an address. If you're writing a contract, especially if you're scribbling something down on a napkin, you want to make sure that you're using more than just a legal description to describe the property that you're trying to purchase or sell. If you found this video helpful, don't forget to like, subscribe, and hit the bell so that you'll be notified for all future videos that'll give you some great real estate tips. If you have any questions or experiences with legal descriptions, I'd love to hear from you in the comments. And until next time, happy investing.